This content is brought to you by Uphold, which is a great platform that makes it easy and simple for you to buy, hold, and sell and earn crypto. You can trade from anything to anything. For example, you could trade between cryptocurrencies and precious metals. It's an amazing platform that I've been using for years. And in fact, I still use to this day because they're one, a great exchange, they're reputable, and they're one of the only exchanges that still lists XRP. Many of the other exchanges have delisted XRP due to the SEC lawsuit, but you can still get XRP on Uphold. So I've interviewed the CEO, the founder, and many other representatives from Uphold over the years, and I'm a fan of this platform. And once again, there's some great features like trading between different assets very easily. You don't have to convert to a currency and so forth. They're used by 10 plus million users. They have over 200 cryptocurrencies, and they have a very easy to use app. The interface is really nice. So I can certainly vouch for this platform. Once again, I've been a user for years. So if you'd like to learn more about Uphold, please visit the link in the description. Welcome back to the Thinking Crypto podcast, your home for cryptocurrency news and interviews. With me today is Lilya Tessler, who's the partner and head of the FinTech and Blockchain Group at Sidley Austin LLP. Lilya, it's great to have you on.
Great. Thanks, Tony, for having me here today.
Well, Lilya, I am excited to speak with you. Recently, on behalf of the Chamber of Digital Commerce, you filed an amicus brief with regards to the SEC Ripple lawsuit. But I would love to start with your background, get to know you a bit better. You know, where you're from, how'd you become a lawyer, things like that.
Yeah, great. No, happy to get started. So in terms of my background, I grew up in New Jersey. I've lived in Jersey most of my life, and during the pandemic, migrated like many other fintechs to the Austin, Texas area, and kind of in the center of some of the tech hub here in Austin. But like many of my clients, I say that I'm decentralized because I see and travel on a regular basis across different Sidley offices. I currently split my time between Sidley's Dallas office and our newly opened Miami office, another big FinTech and blockchain hub that's developing. I've spent a lot of time, just came back from a trip from Miami last week as well. So I'm everywhere in supporting our clients in this area.
So it sounds like your firm supports a lot of blockchain and crypto companies.
Mm-hmm. Yeah, we support a pretty wide range of blockchain clients. I started working with clients pretty early on, merging technology companies in this area. Coinbase actually was one of my first clients back in 2016. So very early on, I started supporting many other layer one protocols and other blockchain technology companies and intermediaries, crypto exchanges, broker dealers, supporting some of the early investments in blockchain digital assets, especially those that are securities and seeking registration with the SEC and FINRA. And now at Sidley, we support also the bigger financial institutions and enterprises looking to enter this space, partner with some of the existing technology companies, or create their own infrastructure to support blockchain and digital assets.
So I have to say, you guys are probably very busy because there's a lot of companies entering the market and building. I'm sure your business is not slow at this point.
No, it's definitely exciting time to be in crypto and blockchain. It's exciting to see and help clients grow and build from smaller enterprises working directly early on with CEOs and CTOs in this area, and now with bigger enterprises. This is, I think, my third crypto winter, and it has not slowed down at all in terms of the amount of work and the amount of types of clients we support. I will say in recent months with the downturn, we have seen more work on the insolvency, restructuring, bankruptcy, more SEC enforcement inquiries that we're seeing clients get. And so that we're able to kind of support from the litigation enforcement perspective some of those clients, but also we're seeing more transactions and certain clients trying to get into investments at a lower valuation, trying to take advantage of M&A opportunities as certain companies, unfortunately, are struggling to get by in the current market conditions.
So from a experience standpoint, as it relates to crypto, you've been here since 2016. So you've got a good amount, like you said, 3 crypto winters. But I'm curious, what was your first encounter with crypto and what was your aha moment?
Mm-hmm. So I was a traditional fintech lawyer representing clients in the securities markets that were building innovative fintechs and fintech products. And Coinbase was one of our first clients in 2016, as I mentioned earlier, and they engaged us to apply the securities laws to digital assets. And that was the first time it looked at Howey and how do you apply Howey in the context of digital assets and whether certain offerings are securities offerings as applied in that framework. We wrote a legal analysis and memo back in late 2016 on the topic. I was part of a team and firm that was writing this analysis, which Coinbase attached and open sourced to the entire community through Coinbase's securities law framework, which was published in December 2016, before the SEC had put out much or any guidance on the application of the Howey test. There were some crypto cases the SEC had published, but the first pivotal guidance was the Dow report in July 2017. So this predated that by 6 months and it started the discussion on how do you think about Howey in the context of digital assets.
So I have to ask, I ask all my guests, do you own any crypto? And if so, which ones?
So I would say diversify my career from my financial holdings, but I do own a small amount of some of the basics, Bitcoin, Ethereum, and also now I have in my wallet my daughter's NFT collection that she's created on her own.
Very cool. So let's talk about the Amicus Brief. Why was this filed and what is the goal?
Mm-hmm. So the Amicus Brief, I file on behalf of the Chamber, really to speak on behalf of the industry and the Chamber's members on being a friend of the court and ensuring the court is aware of what legal precedent exists and what legal precedent doesn't exist as applied to blockchain and digital assets generally and offerings in this area. The Chamber's interest here is to ensure the proper law is considered by the court and the court is aware of the impact their decision, especially on the legal side, will have on the industry as a whole. So the Chamber, this was a follow-on to a brief that I had filed in the SEC versus Telegram case on behalf of the Chamber. And really the premise behind it is making the court aware of what the Howey test is, the Howey test and what an investment contract is. I think many in the market already know, but that the Howey test is really about the investment contract. Right. And it's separate and distinct from the subject of that investment contract. Assets are offered pursuant to investment contracts and need to comply with the securities laws. But what the subject of that investment contract is not itself a security. What that asset represents, the law is currently still unclear on what the subject of investment contract itself represents, but also the brief cites two examples of other investment contracts that had commodities that were subject to investment contract. There were cases about beavers. Oranges are well known. Oranges can be eaten. Beavers can be used for their pelts. Condos can be lived in. So assets could be sold. Some are commodities. There could be assets that are not commodities sold pursuant to investment contracts, but the court needs to distinguish and properly think about what the subject of investment contract is when considering what law applies to an investment contract in the case. It also, the brief goes further in that it talks about the fact that there is no law on a digital asset that was previously sold pursuant to investment contract and later sold in another transaction, whether that's a technology transaction, commercial transaction, or another securities transaction. There's no legal precedent as to the secondary trading. And the court may not even go, the decision may not even go to whether or not it needs to think about secondary trading, but it was important for the Chamber's members to highlight that the fact that there is no legal precedent on that secondary trading component, and also highlights a number of regulatory and legislative initiatives that go to that question that the court could draw from, to the extent it does need to set a precedent on secondary trading.
Yeah, and I'm glad that you guys are there to your point, to educate, inform, and make sure all perspectives and aspects of the law are viewed and taken into consideration. Because, yeah, I without getting too much into my personal feelings, I feel there's certainly a big gap and we're missing the updated Howey tests, I would say, and maybe that's for Congress to act and get an updated version for digital assets and cryptocurrencies.
Mm-hmm. Yeah, and the Howey test really was a case about primary offerings, and that's what the brief discusses. It could be considered in a secondary context, but really hasn't, especially in the context of digital assets, been applied in that context. And I think the SEC is really thoughtful in thinking about this issue. We've seen recent public speeches from the chair's office and various divisions saying we're thinking about what proactive disclosure needs to be put out for registration, alternative disclosures for crypto assets. There may need to be a registration regime for secondary transactions in this area. So they are thinking about what needs to be put out there, and it's positive to hear the SEC saying we're going to put out a disclosure regime similar to asset-backed securities, where there's an alternative disclosure regime because the information that an investor in asset-backed securities needs to have is different than that if you're investing in a company and you're buying equity. Similarly, someone investing in an asset with an underlying crypto asset may need to have access to different network-related information in order to make an informed decision.
Now, I think it was last week. Yes, the brief was approved. What are the next steps given the approval?
Mm-hmm. So the brief was approved. So when we filed a motion for leave of the court to allow us to file. When it was approved on September 21st, we filed with the court the same brief that we filed previously as an exhibit with the judge. So currently, the judge is reviewing that brief along with the motions for summary judgment that are filed by both parties, and it's effectively an opportunity for the judge to consider, but also for each of the parties to consider how they want to respond in their opposition briefs to be filed next month in order to react to some of the legal issues raised in the brief.
Now, some folks are asking, how come the Digital Chamber waited so long to file this brief, because this case has been going on for over a year?
So the Digital Chamber, and I tried to file more than a year ago in terms of having me be admitted to act as counsel to the Digital Chamber as amicus curiae in the case. At that time, the judge rejected that request, said it wasn't timely. And the reason it wasn't timely is typically motions for summary judgment are filed first and amicus briefs are filed after, because it really is about the legal issues in those motions for summary judgment that the amicus curiae is opining on, and that's a time when the judge is considering the legal issues, not the procedural issues. And over the last year, really what the judge was thinking about and making decisions on are discovery motions, not the legal issues that are critical to the case. So when the parties filed on September 13th, the motions for summary judgment, even under seal, we immediately thereafter already in the next day filed this amicus brief in a timely manner, really the earliest that we could file the next day, the brief. And we also did so at a time where we didn't even see typically parties would, or the amicus curiae would want to see the motions for summary judgment. They were filed under seal. So we didn't even see those motions redacted until the following week after we filed our amicus brief.
I appreciate that clarity, because I think folks are wondering what's going on. But to your point, the judge said now it's not the right time when you guys tried to do it at the beginning. Okay, that absolutely makes sense.
And just to also distinguish, and maybe I think a lot of the questions around this was in SEC versus Telegram. We filed much sooner in the process, but that was also a different case. There, the timeline for filing was much faster and expedited because the SEC filed temporary restraining order, and then we're seeking a permanent injunction, and that expedites the discovery period. It expedites the motion period. So in that case, I had to write a lot faster to be able to get the brief submitted than the time that we were able to take here and make sure we got it right.
Yeah, that so certainly makes sense. Now, there's another friend of the court, Attorney John Deaton, and he's representing about 70,000 plus, XRP holders. What are your thoughts on what John is doing? And also just in general, in the world that we live in with social media, you have individual token holders who are upset at the SEC. And it's a different dynamic than I think we've seen historically.
Mm-hmm. Yeah, so I think anyone, the process for Amicus Curie is to be a friend of the court and weigh in on behalf of different interested parties in the case that have a view maybe different than what the parties are writing about in their motions. And I think John Deaton's, as I understand it, his interest in what he's weighing in on is the interest of the XRP holders. What the chamber, in terms of our brief, was weighing in is on behalf of the blockchain industry and the chamber's members generally, which include, they may include blockchain technology companies, issuers, but it also includes market participants, intermediaries in this space, investors in this space, and bringing a broader perspective to what the court should be thinking about and setting legal precedent. So there's definitely room for other amicus briefs in this space that set forth the interests of other parties.
Mm. I don't know if you can take us beyond the curtain a bit, but how are you guys thinking about like how the token holders are affected and their ability to voice their concerns or displeasure or approval of certain things, how these cases are going on social media and content and so forth? Once again, I think it's just a different dynamic and a different world that we're entering in. So I can't imagine like the judge and the folks there who are looking at this also thinking about, hey, there's people who are following this to the T and they're on social media and everything is amplified. I don't know if you have a perspective on that and how things are changing there.
Yeah, so I think it's a lot has changed in the now the digital age of everything being on social media, and I think a lot of people in the market have access to the court filings on a real-time basis faster than they ever seen it before and are analyzing it. I think the judge appropriately probably is not really looking at the social media and all the commentary and views. The judge is focused and should be focused on the filings before it and what the party is. And that's why it's important to have amicus brief submitted, is to ensure that the judge is looking at the critical information that it needs to make its informed decision, as opposed to looking at some of the extraneous information on social media. But just generally, I think in every case, especially in every well-publicized case, not outside of this industry too, there's always a lot of social media and noise and views that market participants have. But I don't think it really impacts or shouldn't impact the way that the courts are making a decision in something like this.
So given the summary judgments that have been put forth by both parties in the lawsuit, and you guys are following your amicus brief and so forth, what's next here? I'm not necessarily looking for predictions, but what would be the next step as far as just the process?
Mm-hmm. So the opposition motions we'll see filed on October 18th, and replies are due November 15th. After that, I think the judge probably late this year, maybe early next year, will make a decision based on assuming the facts aren't in dispute on the legal issues at play. Based on that, we'll see what happens. I think most likely both one or the other party, depending on the decision, could appeal, and so we could see these issues playing out in the appeals court. Another alternative view is there could be, and as we're seeing more guidance from the SEC and them being public, that they may be putting out more guidance on disclosures, and also various legislative bills that are pending. It could be that this case and the issues may be moved depending on what comes out from the SEC in the near term. That also could change the trajectory of the case. So it's hard to predict, but it'll ultimately be either some type of precedent-setting issue in the case, or guidance that may change and shift what's happening in the case. In either instance, I think it's going to be important in looking at what decision the court makes. I think a lot of people in the community are looking at the XRP and how that the facts are going to be determined. But what I'm really looking at, and I think what the industry should be focused on, is how the law is going to be applied in decision of the judge. That was really important. The Telegram case, the judge read the Chamber's amicus brief and really made a decision on the investment contract and was careful to say the digital assets themselves are just code on a blockchain and are not the investment contract themselves. It's a lot of promises, undertakings that then are embodying the investment contract that was offered. And I thought that was a win for the industry and making sure the judge made the right decision. And I think here again, looking at how the judge applies the law, because that's what everyone else in the industry will need to look to in the future precedent setting, not the facts of this case, but the law that the judge is going to set in this decision.
Yeah, and I feel a lot of folks are, anxiously awaiting to see what the decision here is, because I know the SEC has said Bitcoin is not a security. That's kind of gotten it clarity. Ethereum still up in the air based on past individuals saying certain things, but Chairman Gensler has not reiterated those statements. But there's thousands of other coins out there and some great projects that want to know, do we have to leave the United States? Is this Ripple? If Ripple wins, are we going to be able to then maybe use that blueprint to fight our case if the SEC were to come after it?
Mm-hmm. Yeah, and that's what I'm saying. I think that the legal precedent and the way that the judge focuses decision is going to be important. And also it could be that the judge goes similar to the Telegram case where they're focused just on the investment contract and primary offering, and we're still left with awaiting some of this pending SEC guidance or legislative actions on the secondary and how a digital asset that was previously offered under an investment contract is treated for secondary transactions.
So from a crypto regulation standpoint, are there any bills like maybe Senator Lummis and Gillibrand's bill or anything that you feel that has been put out in the past, maybe Token Taxonomy Act, that you feel maybe gets it right and Congress could potentially move forward with?
Yeah. So I'm not going to speculate on what gets it right, because I think each bill has, some are very tailored and specific, and some are very broad to cover the many different regulatory issues and agencies that are impacted by this asset. But the Loomis-Gillibrand Responsible Financial Innovation Act is one that was specifically cited in the Chamber's brief as a potential roadmap for the court to look to, because it does, as at least on the securities side of the issue, distinguish an investment contract from the ancillary asset that is offered pursuant to that investment contract, especially in a world where the network may not be fully decentralized. It also encompasses some of the same messaging around the SEC from a disclosure perspective. It puts under the SEC's purview disclosure requirements for the issuers or registrants of that asset. They have to comply with the SEC's regime for disclosure, but that same ancillary asset may be traded on a spot commodities exchange regulated by the CFTC. So I think that's a good model, or a model that the regulators could look to, or the courts could look to make that distinction. But there's a lot of different bills out there, and certainly there are a lot of different ways to get it right. The important part is to put more out there for the market to be able to read and rely on. And many are trying to do the right thing here and want a framework that works.
Yeah, and I'm hoping they get it right soon enough, and hopefully maybe 2023 is the year that this can be pushed through. And we are seeing more bipartisan support for crypto, Democrats and Republicans, which is a great sign. Until then, I feel like the market's in a bit of a limbo, and we'll have to see what happens next. I don't know if you can talk about this, but are you hearing of other potential SEC enforcement actions or anything else? And once again, obviously there's legal precedent here that you may not be able to talk about any of these things, but I'm curious if you're hearing about any of that.
Yeah, so the trend continues that we are seeing SEC enforcement inquiries representing a number of clients navigating that process, which is, some of them may have already been pending for quite some time, and now there are investigations from the SEC, and now we're seeing clients served with requests for information, voluntary requests for information, or formal subpoenas. We're seeing a trend where in the past, some of those requests were against just token registrants issuers. Now we're seeing them also focus on intermediaries, which aligns with some of the messaging from the SEC. We're seeing investment advisors being served some of these requests, and in crypto exchanges being served requests with respect to certain assets that they support. A lot of the requests follow the themes from the SEC's public speeches that they believe certain assets need to consider whether or not certain intermediaries need to consider whether assets are securities, and if so, may require registration. And I do have a subset of clients that are proactively engaging with the SEC on how do we come in and register, what's the right registration regime for certain assets that we believe are securities, and are engaged proactively with the trading and market staff and chair's office and others on that registration process.
Well, hopefully we don't get too many enforcement actions that go through until Congress acts. But I got some wrap-up questions here for you. First is rapid fire. Favorite food?
Favorite food? Give it some thought. I think any type of pasta dish with truffle mushrooms is my favorite. Love truffles everywhere.
Favorite musician or band?
Journey. Very big into any 80s band, but Journey is my top favorite.
Favorite movie?
Father of the Bride.
Favorite book?
Any travel book. I love traveling, especially to Europe and Italy. So travel books are my go-to.
What do you do for a pastime, hobby?
Playing tennis, which in New Jersey you can only play part of the year, but here in Texas, tennis year round. So it's definitely become addicted to it.
Awesome. And finally, if you could create your own metaverse, what would the theme be?
Theme would be opening up a bake shop, cupcake shop, especially calorie-free baked goods would be ideal. But I've always wanted to open one in the real world, but why not start in the metaverse?
Awesome. Lily, I appreciate you joining me and for the information you've shared. Thank you so much.
Great. Thank you.